Here's with name of your junior, sir. Someone to assist you.
Yes, Devashis Dolensu.
Submits that the matter may be taken up on the 9th of December. Council paying for the respondents do not object to the same. Accordingly, let the matter be listed on 9th of December.
Wait, Your Lordship.
Yes.
Also, I beg to mention item number 3. Also, may this matter be adjourned for a week.
Wait for some time. Let the matter be taken up. Item 3.
Your Lordship, I
2021
think
matter.
being on annual couldn't appear before this court
I
today.
understand, but we'll have to take up the file because it is a 2021 matter. We just cannot let it go.
Yes, my lord.
Yes.
Much obliged.
Any other?
Yes.
Sir?
My lord, I beg to mention item number 4 and 5, my lord.
4 and 5.
My lord,
Yes.
Mr. P.K. Roshidri, my lord, there's some sort problem, my lord.
Hmm.
Can it be
3 and
4 and
5, man.
4 and 5. Yes.
Lords.
It's submitted that Mr. P.K. Roy Chaudhary, for the petitioner, is unable to attend the court proceedings today. Accordingly, a prayer has been made for an adjournment for
my lord, after 1 week.
After 1
week.
week.
Let this is matter after a week. A date to be fixed by the registry.
But there is an interim order
The interim order passed earlier shall appears for the
BNC.
in both the cases, my lord.
Okay. But item 1, subject to my seniors affirmation, my lords. I'll like to seek some time. Today, my lord, I'm having some other matters. My criminal matters are there. People are in jail. My lord.
Giving him liberty to argue first.
Uh,
Let him finish because I have already put my case. And last occasion also, they were supposed to argue, my lord, they did not.
my lord, today only difficulty is I have been appointed amicus in few matters, criminal matters. People are in jail. They will taking up it will be top of the list.
Have it on Thursday?
Thursday.
Thursday would we do so?
Thursday.
So once we take up the matter, we'd like to finish it off.
Yes,
My
yes.
lords, Thursday, my lords.
It could be on Thursday.
Provided they don't take time.
No, no.
Very
They
difficult.
would not.
They're very
Even if he's not there, we'll proceed.
My lords.
Yes,
Okay.
at the request of Mr. D. Gogoi, Learned Council appearing for the respondents, is this matter again on the date 27th of November 2025, full stop, Mr. B.D. Das, and a senior advocate appears with the assistance of so-and-so.
My lords.
Oh, this matter again as a part-heard matter, huh?
It was first item today. It was very easy for me.
We'll take it up early on that day, sir. ठीक है, material. Yes, you are saying?
Yes, well, I'm praying for adjournment. Just a week accommodation I'm praying. He is being on unwell, is unable to appear today.
It is submitted on behalf of the Learned Council appearing for the petitioner that is not in a position to attend the court proceedings today. Full stop. Is this matter after a week on a date to
On
be fixed?
Tuesday, 2nd December, can it come, your lord?
Okay, on 2nd of December 2025. Mr. So-and-so is present for the respondents.
I'm deeply obliged. Your Lordship.
Can it be taken after some time?
After some time,
Lordship, if I may just, Lordship had required us to inform the honorable court if the place where they want to allot land to us is
Mm.
acceptable. We have inquired, Lordship, actually that place is in the middle of the river. It is a chore area. Chore area that is very difficult for us, Lordship.
Mm.
If necessary, we can file an affidavit also to that extent.
Heard Mr. S. D. Leonard Counsel appearing for the petitioner. Heard Mr. A. Bhattacharjee Leonard Government Advocate for the state respondents. By the last order dated 30/10/2025, the petitioners were required to have instructions as to whether the alternate plot of land earmarked for them would suffice their cause. Full stop. Today, the Learned Counsel for the petitioner has submitted that the land is in the middle of the river and therefore may not suffice their cause. Full stop. He prays for some accommodation to file an affidavit in this regard. Stop. This is the matter after 2 weeks on a date to
No,
be
one-
fixed by the
Maybe
registry.
1 week.
1 week. 1 week.
File it.
After 1 week on a date to be fixed by the registry, allowing the petitioners to file the additional affidavit as prayed for.
Obliged.
There's an interim order, Lordship.
The interim order passed earlier shall continue. That is by 1 week.
That is why I prefer a date because it's,
Huh?
I
After a
prefer,
week, they'll fix it.
because the interim order is operating, that's why.
Someone is surviving on a piece of land, we can have that much of.
But we have to give it to APDCL for a project. Greater interest is involved, public interest.
After a week. Like,
My lord, obliged.
yes,
Much obliged. Sorry, my lord.
yes, Mr. Kaushik.
Malad, pursuant to order passed by this honorable court,
Hmm.
8/2/2024, a commission was appointed, Malad.
Hmm.
The hearings and everything has been concluded, Malad. The evidence has been taken, Malad.
Hmm.
The commission is yet to submit the report. Malad.
Hmm. Okay, heard Mr. B. Kaushik. Learned Counsel appearing for the petitioner. Also heard the Learned Counsel appearing for the respondents. Full stop.
Is there?
Yes.
I'm 80 for it. That's why.
Uh-huh.
Standing counsel for 80 for.
The respondent, Malad.
That's one answer.
Get your breath. Get your breath.
The full report to submit, Malad.
By the last order, it was last order, it was observed that the report of the commissioner is awaited. And the matter was fixed for listing today for further consideration along with the report of the commissioner. Is the report not coming up?
Malad,
Why is the report not coming up?
Malad, the
You complicated issues before him, apparently. No. Okay, list again. On 3rd of December 2025. Awaiting the report from the commissioner.
maybe-
Order passed earlier shall
the
continue.
lordship can fix it on the month of January, Malad.
January.
I have been told, Malad, he is drafting the report. Malad.
Okay, then instead of 3rd of December, you put it on 5th of January. Huh? Okay, 5th of January.
Grateful, Malad.
5th will not be correct because even if he prepares it during the vacation, it will not come on record. Keep it after some time. Keep it on the 8th, maybe.
8.
8th of January.
Grateful.
15, so good looking.
16/7.
Lordship,
Yes.
after that, sometime Lordship, he's on legs, Lordship.
Oh, he's on legs after some time.
Yes.
Yes,
For respondent number 4.
after he's playing for after some time.
Yes.
Yes,
So
he had
lordship-
filed an affidavit, he wants to withdraw it. The petitioner had filed an affidavit in reply. And the petitioner wants to withdraw it. The reply. The affidavit filed in reply.
How can it be?
Is there a system of withdrawing an affidavit? Perhaps there is a,
It can be amendment.
it can be amended. It
No,
will
no,
not
the
be.
problem is this, my lord, two affidavits are filed.
Ah,
Affidavit in reply, Respondent number 2 file an affidavit in opposition. I filed first affidavit in reply. Thereafter, what happened, my lord? That affidavit in reply file was not available, record was not available with me. So on the misconception, I filed another affidavit in reply.
Okay.
So I want to withdraw the second affidavit in reply.
No, what we can do is
First one will stand,
we can record your statements,
my lord,
and if it does not contradict the first affidavit in reply,
my lord.
we will ignore the second affidavit in reply.
Second,
But it cannot be withdrawn. I don't think an
No, no,
affidavit
second
sworn
affidavit-
can be withdrawn
but
upon,
that will do, my lord. Second affidavit in reply may be ignored.
will be ignored
Yes.
to the extent that it does not contradict the first affidavit in reply. If you have made contradictory
Lord,
statements, then it will be difficult.
There will be
will-
some problem. There is some contradiction.
In that case, Lordship, it will be.
There was some contradiction. That is why, my lord, we have stated that when this affidavit in reply, first affidavit in reply was filed.
Hmm.
But there is certain contradiction, my lord, because that affidavit in reply was not available with us. That is why one misconception that second affidavit.
But the
in reply-
affidavit is shown by the petitioner,
We-
not
we
by
are-
my learned
No,
friend.
but
We are not
but
on
thing
that.
is this, my lord, two persons. One is Zahirul Islam, another affidavit in reply was filed by another person. So, my lord, there is some contradiction. Your lordship would be pleased to see affidavit in reply, one Zahirul Islam filed. That was first affidavit in reply.
In WPC?
Same WPC. my lord.
1136.
Second affidavit in reply was submitted by Amir.
We'll have to see what is the contradiction. What is the contradiction? You tell us.
Contradiction.
How material it
my
will
lord,
be.
Some patta land in the name of predecessor in interest or.
The
patta-
description of the land or in the description of the land, there is some contradiction.
No, my lord. No, regarding some land in the name of father of the petitioners, respective petitioner. my lord. But somewhere it is stated that there is no patta land. Somewhere it is said that there is some patta land. Explaining that, my lord,
Why don't you file an additional affidavit explaining the contradictions?
my lord.
Why don't you file an additional affidavit explaining the contradictions? I have not heard of the law where it allows that you can withdraw an affidavit.
My lord.
I had the occasion to argue such a matter.
Yeah.
And that was rejected. Because the process, I think the Guwahati High Court has some
Well,
judgments also
it-
to the
it-
effect that it
matter
is
is
withdrawn.
correct. 226, my lord.
226.
226, no doubt, my lord, this procedure, my lord, regarding procedure, it will not come under this miscellaneous proceeding under CPC.
May not be, but
My lord, your lordship,
this is a court of record where we are going entirely on the basis of affidavits.
my lord,
We do not take any evidence. There is no cross-examination. So whatever you say on the affidavit, we believe it to be true.
my lord.
Now, how can that swearing part that I know that this is true based on either knowledge or record,
my lord.
can that be withdrawn? Verified, amended? But affidavit once sworn, can it be withdrawn? You may say that the second affidavit is contains errors or whatever. Withdrawal, I do not. You have to show us something, some law that affidavits can be withdrawn. Will allow you to withdraw it. But if you cannot show that, I don't think affidavits can be withdrawn.
He can amend, he can add something
You
by.
can
way of-
clarify.
Yes.
You can say that, okay, that part was not intended to be sworn as
Got it.
such. Anything you can say. There was a misconception of fact or whatever you want to say. But once you swear it and file it, can it be withdrawn? The writ petition. Even the writ petition is not as such withdrawn. The prayers made are given up for the time being in the present form. How can you take back an affidavit?
And
I
this
swear to
reply
God
is,
the declaration.
and this reply is of the affidavit innovation filed by the
In this
response.
case, my lord, I filed additional affidavit in
Ah,
reply
Please also.
in
please-
connection with the affidavit, second affidavit in reply.
You file a clarification, we can accept that.
by filing an affidavit, my lord.
We can accept that affidavit.
My lord.
Because that is what I said. I would ignore the second affidavit. So far, it does not contradict the first affidavit.
In that case, my lord, your lordship may pass an order that petitioner is allowed to file an additional affidavit in reply in connection with affidavit in reply dated so and so.
I would say that I would allow you some time to have your instructions.
But
In case you find the-
instruction will not do, my lord. It is regarding legal point.
If you file an additional affidavit,
Additional
something with
affidavit, my lord, in connection with affidavit in the second affidavit in reply dated 26/10/2000.
Mr. Sheikh, we don't want to complicate issues.
Second affidavit in reply on 21/10/2024.
If I take up this IA for consideration, then based on precedence, I have to say that you are not allowed to withdraw the evidence. I have to stop there. If you file an additional affidavit, in this IA, I can say that I cannot allow I cannot allow the affidavits to be withdrawn, but in view of the additional affidavit filed, the matter will be considered on merits. That I can order. But I cannot take up this IA and say that, okay, you are allowed to file an additional.
This
affidavit.
case will be closed then.
It will be closed once you file the additional affidavit,
my lord.
clarifying the issue. Then I can close the miss case and say that since the additional affidavit has been filed, matter will be heard on merits.
Yes, ma'am.
When will you file it? How much time?
But, after 2 weeks, my lord.
2 weeks. Heard Mr. M. A. Sheikh, learned counsel for the petitioner, also heard Mr. Son for the respondents. Stop. This matter again after 2 weeks on a
Yes.
date to be fixed by the registry, allowing Mr. M. A. Sheikh to file additional affidavit as proposed.
Oblige, much.
Kindly, Mr. Bhattaji, kindly find out that law that affidavits cannot be withdrawn. If you get the citation. Yes.
Only one thing, my lord, I want to say that
Hmm.
affidavit is a pleading, my lord. Affidavit is a pleading.
I have requested Mr.
My
Bhattacharya
lord,
to find out that.
my humble submission before your lordship, if it is considered that it is a pleading, then pleading can be withdrawn.
That is what I was trying to say.
Lord, because my lord,
It's
read
that-
petition,
This is,
if it, read petition will file. Read petition will file by an affidavit.
the petition
If
is
your
withdrawn.
lordship, if your lordship consider that affidavit in reply cannot be withdrawn, in that case, that read petition also filed on the basis of an affidavit. And in that case, affidavit is withdrawn, that read petition is always withdrawn. It is a
Petition
matter
is
of pleading.
withdrawn, the prayer which is
My lord,
made.
your lordship, let it happen, my lord, let me see the legal.
Uh-huh.
Let me see the legal position after 2 weeks, my lord,
I kept it after 2 weeks,
Yes.
allowing you to file an additional affidavit.
my lord.
Allowing you to file an affidavit. You want to file, you file. You don't want to file, we'll decide it on merits.
May I please? Kalle password matter for timing loads. And let's say because PKT is running loads. The part of
Yes,
matter.
A two passover, dear. The passover needs to be done.
Whatever. Whatever.
But here the petitioner is a contractor, my lord, registered under Public Works Authority. And my lord, the respondent authority published one NIT, my lord. And based on that NIT, the petitioner participated in the NIT and he is declared as L2 bidder, my lord.
Hmm.
And that is a case. Page 14, my lord.
Oh, yes.
He is declared as L2 bidder, my lord.
Hmm.
But my lord, L1 bidder does not fulfill the condition of the NIT.
Hmm.
As per the NIT, the rate should not be deferred, should below 5%, my lord.
Hmm.
But he is deferred by 10.1%.
Hmm.
10.1%. One
Ten
paper.
point one, he differs on the law, yes.
But the respondent authority trying to allot the work to L3 beta, my lord, for which the petitioner appeared before this honorable court, my lord.
Okay.
And my lord, on 4/12/2023, there is a direction of the court, my lord, that till next date fixed, no final decision shall be taken. But the respondent authority allotted the work to L3 bidder, my lord,
During pendency
during the pendency of
during
the,
pendency of the stay order.
of the
Yes, who appears for the respondents?
I'm for a private respondent. Lordship.
Yes.
In this regard, Lordship, affidavit is filed by the department. And in that affidavit, Lordship, they are saying that on the basis of the previous record of his Lordship, they have not chosen him and affidavit. Otherwise, we are Lordship, we stand with the observation that is taken by the department Lordship, because I am the private respondent. And this allotment was given to us. And as part of department Lordship affidavit, they have not done proper work in previous occasions. And that's why Lordship, they were not given a role. They have filed the affidavit.
as per the affidavit filed by the official respondent, they said that due to poor performance showing in during execution of the previous work under this division, it was not
Who
accepted.
appears for the respondent number two, PWRD?
P. Nair.
Must be on his legs. Yes, that they cannot give it to anybody else but to L2. Where is that law?
My lord, they taken the step that due to poor performance, they have not allowed the work to me.
To stick to that, sir, then can we evaluate your performance?
My lord, a comparison, comparative chart is also there, my lord. Page 13, my lord. As per this comparative statement, my lord, L3 bidder does not even have the required machinery, my lord, also. Page number 13 is the comparative chart. But the instant petitioner fulfill all the conditions, my lord.
Let us wait for some time.
Okay.
Yes, respondents, non-traverse. I'm allowing the repetition.
Yes, file it.
Huh?
We have
You filed an
affidavit.
affidavit.
Yes, ma'am.
Very good.
Was file on 5/5.
There is no reply to it. What have you said in the affidavit?
About the lordship come to para 17, my lord.
Ella?
17, page 79. Circle of Officer. 17, 1, 2, 3, my lord. They are not landless, my lord. Moreover, my lord, there's
And the land that they were occupying, their land was taken for
compensation was
acquired,
paid.
or the land that they were occupying, which was acquired?
They are already staying in different plot of lands, my lord.
No, the land which was acquired, was it their land or was it?
They were they have got the possession, my lord. That has been acquired. Compensation was paid. And my lord, and they want settlement in the land near the highway, which is against the land policy of 2019, my lord. If my affidavit said, my lord,
Any promise of settlement for
that
settlement when
that statements
is
made in
acquired?
the 17.1, my lord, page 79.
Have you seen the prayer? Please see the prayer.
Already evicted, my lord, 18.
Issue notice to the respondents as to why
Ah.
the petitioners should not be evicted. They pass a direction to evict them. You are ready to evict them.
They have applied under Basundhara 2. That has been rejected. Also, my lord.
It has. After Inter.
Let it come, my lord, after vacation.
Huh?
After vacation, because they were not interested. Have they been interested at least?
What is the interim order?
Interim kiba ase neki?
6/120. Impugn notices shall remain stayed, so they are not being evicted from where? You wanted to evict them from where? From that four-laning part?
The 3 lesser of land bear, my lord.
No, near that four-laning, the land which was acquired, that part.
Yes, my lord. There.
Go through the records, kindly find out what is the interim about, how is it affecting the government?
Yes.
May I please, Your Lordship, kindly
Yes.
peruse last order dated 16/9/2025. Lordship, I appreciate
15/9.
16/9.
Just
I was directed to submit the land acquisition plan, Lordship. So I have received the instruction, Lordship. Land acquisition plan is everything with the Karbi Anglong Authority, and Lordship, that portion of land is forest land. So Lordship, land acquisition plan, I think not available. So this is my instruction.
you do not know which part of land was acquired. You do not have any map.
No, land, I have filed affidavit, Lordship. But regarding Lordship claim of the petitioner, Lordship, on last occasion,
The records are required to include the map approved by the ministry.
yes.
So once you take up the work,
Yes.
You must have been supplied a map that
Lordship,
this
it
is the
is
land.
from the side of the Kala, it is to be Lordship, but that aforesaid portion, that portion of land is relates to forest land, Lordship, so.
Could not have been acquired is your,
Yes, Lordship, petitioner's land is not acquired, Lordship.
Hello, Lordship. Basically, this matter will be taken after some time. Your Lordship, arguing council is on lakes and at lower court, Your Lordship.
And
If
the
I
forest
keep it-
clearance also,
if I give everything for after some time, I will have no one on legs here. Be difficult for me. Yes, sir.
My lord, the competent authority for land acquisition is appointed by the central government. In this particular case, for acquisition of the land for NH 29, my lord, Joint Secretary, Department of Revenue, Karbi Anglong Autonomous Council was appointed as a competent authority for land acquisition. So the land acquisition plan was prepared, my lord, that was sent to the, my lord, NHIDCL. After approval of the NHIDCL, land acquisition plan is finalized. We have filed the affidavit, we have enclosed a copy of the land acquisition plan in our affidavit. But the petitioner has doubted about the genuineness of the, my lord, that plan.
Right.
So the honorable court passed an order directing to furnish the original copy of the land acquisition plan. That direction was issued to the NHIDCL, my lord. Accordingly, NHIDCL, last now he submitted that the land acquisition plan is not with him. So the land acquisition plan definitely with my lord Kala, my lord. Lordship have done sometime will furnish the original copy of the land acquisition plan, my lord. 7 days, my lord, next week. Submit the original document, my lord.
Heard Mr. So-and-so Learned Counsel appearing for the petitioner. Also heard Mr. J. Sutia Learned Counsel appearing for KAC as well as Shri R.K. Talukdar Learned Standing Counsel,
NHIDCL.
DCL.
Yes, Lordship.
The attention of this court has been drawn to the order dated 16/9/2025, by which the Learned Standing Council, NHIDCL, was required to produce the records containing the original, containing the map
Land acquisition.
of the land acquired. Full stop. Today, a instruction issued to the Learned Standing Council has been produced before this court, which states that
Paragraph 2.1.
all the relevant documents, including approved land acquisition plan, is under the custody of Joint Secretary cum Competent Authority for Land Acquisition, Karbi Anglong Autonomous Council, DIFU. Full stop. In view of the above instruction, Mr. J. Sutia, Learned Counsel appearing for the KAC, has sought for an accommodation of 2 weeks to have his instructions as to whether the records can be produced, are available and can be produced on the, are available with the authorities of the KAC.
Kala.
Full stop. Place this matter again after 2 weeks. Do you need a fixed date?
Lordship. Can't dead many fix, Lordship.
On 12th of December 2025, allowing allowing the Standing Council for the KAC to have its instructions and produce the records
My lord.
if available.
My lord.
Any interim order is there? No.
Lord.
Lord, in this case, my lord, the respondent number 7 has filed an affidavit. There was a direction from this honorable court to furnish us a copy. But that copy has not been served and he has made a serious allegation against us also, my lord. So,
Who is appearing for respondent number 7?
M. Hussain.
Yes,
Yes, sir.
copy has not been served to me also.
Yes, sir. What is the subject matter?
It's in regard to the,
Yes, how much cost? How much cost? We had an order of 12/11/2025. Matter relates to the
election of the
election of president and vice president of South Salmara, Mankachar Zilla Parishad. You are the persons who have been elected. You refuse to serve copies to the respondents. Case is being hung up only because you have not served the copies.
As at what did you?
Huh? Why was it not furnished earlier? Give us some reason if you do not have to impose cost. Yes. Huh? Nothing doing. 5,000. Per party 5,000. We are not very pleased when the litigants do not listen to us. When officers of the court. Yes. And there was, I think, some instruction to the registry not to accept copies when all parties are not served.
Because that's under the High Court rules also, you are required to do it. And there are earlier notification.
There is
also-
no, but High Court rule doesn't, this is different, but they have to serve the copy. That's the end of the.
To every.
They have to send. High Court rules we know, but they have to serve individual. That's the.
Filing or reason হেৰি আছে in charge আছে তেখেতক আগতে এবাৰ মই মাহমান আগতে কৈছিলো when was that affidavit filed respondent number 7/11/9/2025 হয় জানো and what about respondent number 4's copy everybody has got
First copy I have not got.
Huh?
I have not got. Respondent number 6 I am appeared. Respondent number 4 copy I have not got.
and you are respondent number 6 your
and
copy has been served to everyone
7th copy has.
I am appearing for respondent number 5, I have got that. Except my gentleman's.
sorry so respondent number 4 copy has been served on
Not to me only.
who appears for respondent number 4
But this is a government,
Government, DC.
Deputy Commissioner.
5,000 on you also per person who has not been served per party
It is 1670.
because even everybody is ready to argue. I have to adjourn the matter. People have been waiting for this. Filing up.
Else file matter.
Let us have it sorted out today. If they want a judicial order on this, we'll have a judicial order.
As the matter was fixed, there was urgency from our side also.
Naturally, it's an election process. People are building power. People are taking decisions for the society. Yes. After 6 months, we decide that no, you were wrongly appointed. What happens to all the decisions already taken? There was a judicial order. Yes, Lord. We'll hold you, we can either hold you in contempt or we can impose costs. Choice.
So far, his role is concerned, he is supporting the case of the petitioners only. We are for the respondent. So that's why his affidavit, he is not enjoying the power. He is supporting the case of the petitioner. We are.
So far, I'm just,
Yes.
I have not gone into the file, but
He is supporting the
but
case.
there'll be some.
He is at the district level supporting the case of the petitioner.
The hand in glove will be, has to be issued. Can we do that?
The affidavit is important for us.
And yes, who appeared for the government on the last occasion? Yes, learned counsel appearing for the respondent number 4. The government shall furnish a copy of the affidavit in opposition filed by the district commissioner to the council assisting Mr. So-and-so on or before 13/11.
That was served to.
Served.
That was served only to my friend was not served. Because our office thought that only to that council has to be served. That's why I lost it.
Here, the persons in the office are thinking that people can argue without an affidavit.
That.
This comes down very heavily today. This trend has to stop. I do not have a copy, I do not have a copy, and the arguments are not carried out. This has to stop today. Take down. We'll have to take it up next week or something.
I'm sorry, ma'am.
We'll have to take it up on the next week or something
Yes,
because
whatever.
after everybody has a copy, then we
Yes,
can take
correct,
a
correct. Right.
Subject to convenience of my learned
Mm.
friend also. It can be taken up for disposal on 11th is a Thursday.
It becomes very late because nowadays, let it be on 9th, my lord, if it is not, 9th is Tuesday.
8 and 9th I am in Imphal. So I am seeking a little accommodation from my friends.
আগত কৰিলে হ'ল তেতিয়াহ'লে। Let it be next week then. EFS difficulty day after.
Fifth of, I'm there in fifth.
It's a,
On fifth, I'm here, Malik.
it's a Friday. The list could be long.
So let it be on then.
If it is
Thursday,
fourth,
on where?
Fourth, I'm not there.
Third, my lord.
Third?
Third is Wednesday.
Third.
Third,
fifth, take a chance on fifth then.
Yes, ma'am.
fifth.
Yes.
On fifth, we can take a
If
chance.
Leonard Senior has some problem.
Just come up for, এইটো কিহত আহিছে, admission আহিছে. Admission আহিলে ওপৰত থাকি যাব অলপমান, নাথাকে ন। আপুনি registry মাতিছে নে কাবাক? Filing মাতিছে নে কাবাক?
That's, I will not ask your lordship to make it top of the list, but we'll try to mention it
We'll keep it
Yeah.
on the fifth.
fifth. And I will be at liberty to mention this matter.
Yes, heard. He does run a senior counsel appearing for the petitioner assisted by Mr. Swensu. Learned counsel. The petitioner, full stop, yes.
I'm for item number 4962 of 2025.
Are you assisting, sir, or he is assisting? You're assisting, huh? He will be assisting, huh? Mr. R.M. Dekar, learned counsel appearing, appears for the petitioners in WPC 4617.
4962.
Huh?
4962.
4962 of
25.
2025. Mr. Das, you are appearing for 4617.
Yes, yes.
4617. Also heard Mr. B.D. Kaur, learned senior counsel appearing for the respondent number 5
In
in
both-
WPC number, in both the petitions. Also heard Mr. So-and-so, your name, sir?
Yeah, Hussein Lordship.
M. Hussein, learned counsel appearing for the respondent number 6 and 7 in
No,
WPC. Oh,
I'm for
respondent
seven.
number
7 Lordship.
7 in WPC number
4962.
4962. Also heard Mr. So-and-so, learned counsel appearing for respondent number
6 in both the cases.
6 in both the cases. Mr. S.S. Roy has entered appearance
02.
on behalf of the respondent
192.
number
Four.
4.
625.
Who appears for 1, 2, and 3? Huh? You are appearing for Mr. R. Dubey for respondent number 3. The 1 and 2. A.K. Ghosh on behalf of Mr. A.K. Datta, learned counsel, S. Datta, learned standing, learned government advocate, huh? Yes, by the last order dated 12/11/2025. This court had observed that copies of affidavits filed by the parties had not been exchanged in totality by serving all the counsels representing the contesting parties. Accordingly, orders were passed requiring the learned counsel for the respondent number 4 and the respondent number 6 and 7.
Well, 7.
Huh? Eta order copy eta print out liye dioksun to. The order says 6 and 7. You want to correct us? The order? You want us to correct that order?
No, sorry.
Interruptions will again cost. When you're passing an order, please do not interrupt. Because you are reading the order and passing the order. Do you have the order before you? No.
No.
Then
Yes, sir.
requiring the respondent number 6 and 7 to ensure that a copy of the affidavit filed by them shall be furnished to the learned counsel assisting Mr. B.D. Kaur, learned senior counsel by 13/11/2022. Within bracket, you write 2025.
Saturday.
Ah. Today, when the matter is called up, it appears that the affidavit in opposition filed by the respondent number 7 in the 2 writ petitions have not yet been supplied to the counsel appearing for the respondent number 5. The affidavit in opposition filed by the respondent number 4 has also not been served upon the on the respondent number 6. Full stop. The matter relates to election of the vice president of the
South Salmara Mankasar Jila Parishad.
Jila Parishad, full stop. Notices were issued on 29/8/2025 and by the order dated 12/11/2025, the aforesaid had been observed, full stop. This court has noticed that in several matters, the counsels appearing for the contesting parties do not take the pain to serve copies of pleadings on all the counsels appearing for the parties, full stop. This has hampered consideration of matters, and on several occasions matters have been adjourned only for supplying copies to the contesting parties, full stop. In the present case, we find a violation of a judicial order passed for supply of copies to the contesting parties, full stop. The learned counsel for the respondents number 7 and respondent number 4 are afforded one opportunity to complete their pleadings, to complete the service of all pleadings filed on all the contesting parties within a period of 2 days from today, subject to deposition of cost of rupees 5,000 to the district legal aid, district legal aid services, full stop. This matter again on 5th of December 2025, full stop. The registry is also directed to ensure that no copies of pleadings would be allowed to be taken on record unless counsels appearing for all the contesting parties in a particular matter are served or undertakings are given to serve the copies before listing of the particular case. Stop. List as directed.
May I make a short comment? Well, respondent number 7 has conducted an inquiry. He may be directed to bring the copy of the inquiry because we don't want to delay this matter again. This inquiry report in regard to this issue has already been conducted.
No, my lord, they do not have any pleadings. Where from they get this authority, my lord?
No, they are this.
No,
respondent
no, no.
number
On
7.
one hand, you are taking the plea that you are handicapped because the pleadings are not shared with you. How come you are getting all these documents?
No, this is not part of the pleading, sir.
When you do not have the pleadings, how do you know what is the subject matter? That's what I'm trying to question.
This is in regard to the same issue. They have conducted an inquiry.
Why are we looking at a piece of paper by some political party?
Exactly.
This is respondent number 7. They are.
You may do whatever you want to. Should we look into their internal party
He is
communications?
preparing for respondent number 7. Why is he?
No, my respondent number friend is appearing for respondent.
He will be like, why are you
make a
coming to
request to the senior counsel, sir?
No, my lord, what I'm saying is,
We go by the record of the deputy commissioner. My lord. Deputy commissioner has supported us. He is supporting the petitioners. That's the.
We go by the pleadings on record.
Yes.
It will not be,
Yes. We'll
what
argue on
has
the.
baffled me is he is appearing for some other respondent.
No, in
He is
the
trying to
morning,
plead for
your
respondent number
payment
7.
I was today morning contemplating what to do if two senior advocates discuss the matter in the court, which is not there in the pleadings. I could not find a solution. Let me not find a solution, sir.
Yes.
We'll go by the pleadings. Don't we?
Yes.
We'll go by pleadings. We'll take
This
it
is
up on fifth.
basically a point of law. We'll argue on.
Yes, sir.
It's okay, fine.
I am for private respondent, madam.
Number?
Political party.
Record presence for respondent number 7. Also heard Mr. Interest of the Learned Council appearing for the respondent number 7 in WPC number of both the WPCs.
Yes, yes, yes. 4962, Lordship. In which the cost of 5,000 is awarded.
Yes. Due to non-exchange of pleadings, sir, we had to impose costs because there was an order earlier from this court to exchange of pleadings. Only because the copies have not been served, we could not take it up today. Some action has to come. There is a judicial order, I cannot overlook it. Yes.
Should be done, otherwise it will not expedite my matter.
আগতো এবাৰ ৰিকুৱেষ্ট কৰিছিলো এতিয়া এবাৰ মনত পেলাই দিছো যিমান পাৰ্টি থাকিব সাৰ্ভিসৰ কাৰণে পেটিশনাৰৰ যদি কপি সাৰ্ভ কৰে লগত যদি পেটিশনাৰ যদি 5 জন আছে 2 জন যদি এপিয়াৰ কৰে তেনে সিজনক দিব লগা ঠিক ৰেসপন্ডেন্ট এজনে সাৰ্ভ কৰিছে সব ৰেসপন্ডেন্টক কপি দিব লাগিব এফিডেভিট যি ডকুমেন্ট কোৰ্টত ফাইলিংত সোমাব তো সবে কপি পাই সোমাব সবে কপি পাব লাগিব সাৰ্ভিসৰ এফিডেভিট হক হেৰি এফিডেভিট কোনবাই যদি দিব পৰা নাই উকিল নাই কোনো ৰিপ্ৰেজেন্টেশন নাই ওকালতনামাত কোনো নাই আন্ডাৰটেকিং দিব যে ওকালতনামাত নাই একাৰণে মই সাৰ্ভ কৰা নাই বা হেজন উকিলক বিচাৰি পোৱা নাই মই নেক্সট ষ্টেটত লিষ্টিংৰ আগতে মই সাৰ্ভ কৰিম unless that is done don't take copies মই অৰ্ডাৰ পাস কৰিছো এইটো ইয়াতে আহিলে মই কপি পোৱা নাই মই কপি পোৱা নাই বুলি মই দি থাকিলে কিটো হ'ব কপি পোৱা নাই কেছ নুঠিব তাতে কি ৰৈ থাকিব সাৰ্ভ কৰাব কিন্তু কপি নোহোৱাকে নিদিব এনে সময়খিনি গৈছে মোৰ আধা ঘণ্টাটো মই এনেই মই এটা দিলো মই জুডিচিয়েল অৰ্ডাৰ কিয় দিব লাগে আপোনাক copies have to be given to everybody. Lower court কেতিয়াবা পাইছে নেকি যে হেৰিক নিদিয়াকে ডিফেন্স নিদিয়াকে কোনোবা এখন কপি আহিছে বুলি শুনিছে নাই শুনা সবকে কপি দিব লাগিব ইয়াৰ আমাৰ ইয়াৰ হাইকোৰ্ট কেলে নহব উইদাউট কপিজ অৰ্ডাৰ what process is required but copies will not be allowed to be filed without everybody being served or an undertaking তে মই নেক্সট ডেটৰ আগতে সাৰ্ভ কৰিম প্ৰাইভেট পাৰ্টি 5টা আছে 3 জনক এজন উকিলে ৰিপ্ৰেজেন্ট কৰিছে 2 জনক এজন উকিলে ৰিপ্ৰেজেন্ট কৰিছে এইজন উকিলৰ সঙ্গে লাগিব যত উকিল নাই অন ৰেকৰ্ড তাত লিখি দিব নহয় যে ৰেসপন্ডেন্ট নম্বৰ 6 and 7 ৰ কাৰণে নো ওকালতনামা এভেইলেবল তাক ফাইল কৰিব কেএছৰ গোটেইজন উকিলৰ নাম্বাৰ থাকে নাম থাকে নাই যদি নাই সেইটো লিখি দিব তেওঁ যে নাই কাৰণে মই দিব পাৰা নাই sort it out however you want to do it but respondents copy নোপোৱাকে don't put up
Last to trouble your lordship,
Yes.
if it is not inconvenient for the court. So can we mention it on that day for updation of the matter, my lord? Because these are election matter.
if it comes before this court
Yes.
the liberty
that's
is
all.
always there
Yes, right.
but is always
Right. Deeply.
I think there was earlier notification. I remember, but I have to look into it.
Lordship, I humbly apologize, my lord, on behalf of Mr. P.K. Tiwari. My lord, he's on his way, my lord. My lord, can it be taken up the second half, my lord, if your lordship is inclined to sit? Can it be taken up in the second half, my lord? At 2, he is on his way, in fact.
last time we were trying to discuss
Yes, my lord.
something had suddenly come up some point had suddenly come up
Yes,
for
ma'am.
which we had to we'll try it after some time let us see if how many matters more are there let us see if
Very
start it after the 2 matters otherwise we have it on Thursday
Very well, my lord. Duta matter or else Thursday.
if the matter reaches by the end of the list on Thursday
Highly obliged, my lord.
yes
19.6 the lordship With the directions to produce the record there,
Of
that,
By whom?
by the PWD department. That will reveal everything.
1906.
1906.
Mr. M. Bhuya shall
Yes.
produce the records.
That will
Who
reveal
appears for the
everything.
PWD?
Yes.
Standing Council PWD at a scroll diopson. Standing Council PWD at a scroll diop. You are appearing for
I am for the private. The
private respondent. You have not filed your affidavit.
I have not filed the affidavit. I have
We
supported
hear
this
you.
plan whether
We don't need to
by
hear
the.
you. Now
department.
kindly tell us when you have not given the data for 23, 24.
Yeah, bro, my lord, I am. paying
You have
for-
submitted your balance sheet only for 1 year. Then you have given a bank credit facility issued to some other
Yeah, bro, my lord,
person.
on that occasion.
Then work experience subcontract was there. Then tools and machinery, not as per tender requirement.
My-
Why will you?
Therefore, that by order to the 1906,
Ah.
record was called for, my lord. Reveal everything. What I
Tell
have
us,
submitted, my
tell us how you overcome this. You must have overcome these objections by some manner. You must have some documents. You must have submitted something. No. You did nothing.
lord. No, my lord,
And they were benevolent with public money. Risha Infrastructure, get me that order. Yes.
on time, for the record.
And then there was an order not to give you the, no, not to take a final decision. You have been awarded. Have you completed some work? You have not started it.
But I have, furnished the performance security of 94,000. That is.
So
That is
when,
the
did you know
resident-
about, did you know about the orders of this court that yes, no final order should be passed? You knew about that order?
Yes.
After that, the final order was passed? Huh? You said there is a stay and work has been allotted. Has work been allotted to you?
2023 interim order is there.
Yes, well, prior to that, 31/10/2023, there is a direction to deposit the performance. Prior to that.
Where is the stay order?
4/12/2023, my lord.
Huh?
4/12/2023, my lord.
4/12/2023. No final decision be taken. And when do you say was the decision taken?
It was on 31/10/2023. That's it.
In? So it was done after the interim order was passed after?
Thereafter.
You have not received any formal work order?
No.
Yes. No, I don't think there is any violation. He was asked to deposit whatever he has deposited before the passing of the interim
Well.
order. Your interim order came in December. That took place in October.
October.
Yes, sir. Can you explain? Did you fulfill the tender conditions at all?
My lord, that start his annex, my lord, it shows
Yes.
that, yes, my lord.
It's false.
Therefore, I pray for the record of the case.
You would have to.
Let the departmental
You
council.
would have
he
to,
explain.
you would have to tell us. If you cannot say whether it was provided or not,
To my information, that all the documents have been provided. my lord.
after the tender was opened and a chart has been made.
No, then that is not.
Hmm.
I had the instruction said that all the necessary documents was produced.
Hmm?
All the necessary documents were produced, my lord,
When?
at the time of tender.
Then this comparison table is wrong.
My lord, let the record come, my lord. Let the record come. If anything reveals against me, my lord, will face the consequence.
Heard Mr. P.K. Mazumdar, learned counsel, appearing for the
Yes, sir. Respondent number 7.
for yes.
Respondent number 7.
Appearing for respondent number
7.
7. By the order dated 19/025, this court had directed the production of records by the learned by respondent number 1, 2, 4, and 5. The subsequent 2 occasions could not be taken up due to reasons reflected in the orders itself. Today, when the matter is called, none appears for the respondent number 1, 4, and 5. Come to and 4. Four and 5. Yes, none appears for the respondent number 1, 2, 4, and 5. Full stop. Is this matter again on day after tomorrow, Duke? Yes, would be ready. 27th to enable the learned to enable the production of records on
Update.
none appears for the petition when the matter is called. Full stop. And the council
2, 3, my lord.
has put in appearance for respondent
2
number
and 3.
2 and 3. Full stop. An interim order to what effect?
My lord, case 61 is the impugned notice, my lord.
Huh? For what?
If your lordship comes for time being, my lord. So DAG number 275. It is selling surplus land, my lord, of the T estate grant number 654. And reply to that, it will come in page 76 of my reply. It says, my lord, that with regard to the statements made in the para for answering deponent beg to state that a portion of the land measuring 3 lessers only remaining under the position of the petitioner under DAG number 275 of Gopur T Estate 654 grant through the petitioner has not been permanently residing over there. According to the land policy of 2019, no allotment can be granted for any land situated near the 4 lane of the national highway. It's only a 3 lessers, my lord, where the impugned notice has been issued, my lord, which has been stated by this honorable lord. And since, my lord, they failed to turn up, my lord, interim
2 and 3, no? They have appeared for respondent number 2 and 3. By the order dated 6/1/2025, this matter was required to be listed for hearing in its usual course. Stop. The bone of contention in writ petition was the notice dated 12/7/2024,
24.
by which the petitioners were ordered to vacate the land which was allegedly illegally occupied by the petitioners under DAG number 275 within bracket sealing surplus government land in Gopur Tea Estate grant number 654 full stop. The respondents in their affidavit have stated that the land revenue for the land covered under DAG number 275 was not paid by any, was not paid, and only a portion of 3
May I please,
lesses
Your Lordship?
remain. Yes.
My actually, in favor of Bonita Tanti, we are appeared. My senior is out of station.
None appears. Did I write anywhere none appears for the appeal? Miss so and so appears for you.
AC Buragohai. On behalf of AC Buragohai, he is out of station, J Tamuli.
Being on behalf of Mr. A.C. Buragohai, Commander and Senior Advocate. Di. লিখি আছিলো, merely three lessers land remain under the possession of the petitioner under the said DAG. It is also stated that the petitioner is not residing permanently over the said land. It is the stand of the respondents that the petitioners have. Somewhere I read it in this, somewhere else. They have some other land also.
Para 21.
Para 21.
21.
Para 17 also.
Para 17 and 21 also. 1021 it says Bonita Tanti as a permanent residence under DAG number 355.
The respondents have also stated that one of the petitioners, or is it only one petitioner?
No.
One of the petitioners, that is petitioner number 1, has a permanent residence under DAG number 355 in Kurupbari Tea Estate 28 WA grant, and petitioner number 2
Fayaz Ahmed
as a
page-
permanent resident at DAG number 204 in Gopur Tea Estate 654 grant full stop. Petitioners have not responded to the affidavit in opposition filed by the respondents full stop. Since a prayer has been made today on behalf of the learned senior counsel appearing for the petitioner for an accommodation as he is out of station, place this matter again after 2 weeks on a date to be fixed by the registry for hearing.
Pleasure.
for final consideration.
Huh?
Final consideration hearing. Final consideration.
We cannot now break it into subcategories, hearing, final hearing, sub-hearing. We can't do that. We keep it for hearing.
Interim, my lord, it will continue, it is vacated.
Interim is there. Interim order, if any, shall continue till the next date of listing.
Extremely sorry, my lord. In fact, I never thought that 13, 14 cases before me will be over in a jiffy. It seems, my lord, no one is keen on doing cases.
You can say it is grace of God.
Anyway, my lord.
Yes.
I'll start from where I last ended. I distinctly recall your lordship had reflected upon the ratio in the Nayak case, the Constitution bench. And my lord spoke about the nature of the reference. Lordship doubted the correctness of the reference also. As to whether, because if the ratio of the syndicate bank has to be understood as meaning that it is not only the justification but also the legality thereof, namely whether it is a strike or the lockout as the case may be, which has to be seen and understood and examined to come to a conclusion as to whether one is entitled to wages or not, then certainly, my lord, from that very perspective, the reference is flawed. There is no doubt about it. But the question would be, my lord, reference was never challenged. Reference was never challenged. The reference was decided. Reference was examined and gone into. Whether, my lord, at this stage would alter the judgment on the basis of incorrect reference would be an issue for my lord's consideration. And I leave this to your lordship. We have no say over the matter. Because, my lord, I did look into Syndicate Bank. The ratio apparently is very clear because the same ratio was reiterated by a subsequent Supreme Court bench in the HAL case. I will refer to both. But interestingly, my lord, the Syndicate Bank, I will first of all come to that. Let us look into the very nature of the observations made by the Supreme Court in the Syndicate Bank. The law of lord has been discussed in 2 paragraphs. Whether my lord is having the copy of the Syndicate Bank.
I'm trying to trace out that. Yes, Syndicate Bank and another.
Whether my
Umesh Nayak.
copy, otherwise.
No, Umesh Nayak. Yes, we have a copy.
Very well.
We have a copy.
In 2 paragraphs, my lord, at page 589, Supreme Court discusses the law on the issue.
Yes.
And I read these 2 paragraphs. Thereafter, I will come to HAL. Para 24, there is therefore nothing in the decisions of this court in Churakulam Tea State and Crompton Greaves cases or the other earlier decisions cited above, which is contrary to the view taken in T.S. Kelawala. Now, my lord, pausing here, I clarify, I did read T.S. Kelawala. And my lord, I must confess I was thoroughly confused. It is worded in such a manner that practically no ratio can be cured out. The T.S. Kelawala is based on the facts of a particular case, and specifically observations of this nature, my lord, we would not find. But we can draw certain inferences from there. But be that as it may, it is Supreme Court. So, my lord, they are the final arbiter. We can't really comment on them. It is their understanding. What is held in the said decisions is that, and this is what the ratio is. What is held in the said decisions is that to entitle the workmen to the wages for the strike period, the strike has both to be legal and justified. In other words, if the strike is only legal but not justified, or if the strike is illegal though justified, the workers are not entitled to the wages for the strike period. In fact, in India General Navigation case, the court has taken a view that a strike which is illegal cannot at the same time be justifiable. According to that view, in all cases of illegal strike, the employer is entitled to deduct wages for the period of strike and also to take disciplinary action. This is particularly so in public utility services. Of course, ours is not a public utility service. Para 25, we therefore hold, now the court holds, endorsing the view taken in T.S. Kelawala, that the workers are not entitled to wages for the strike period, even if the strike is legal. To be entitled to the wages for the strike period, the strike has to be both legal and justified. Whether the strike is legal or justified are questions of fact to be decided on the evidence on record. Under the Act, the question has to be decided by the industrial adjudicator, it being an industrial dispute within the meaning of the Act. So, my lord, ratio is very clear. The court clearly holds, because whether it is a strike or whether it is a lockout, both will not have to be tested on the same touchstone. The principles are the same. So, if whether or not workers are entitled to the wages during the lockout period, the reference ought to have been as to whether the lockout was legal and justified. But below again, Again, there is a caveat, because as my lord knows very well, the legality of the lockout or the legality of the strike, if we look into the statutory prescriptions under the Industrial Disputes Act, Section 23, etc., 22, 23, etc., the legality of the lockout is also dependent upon the legality of the strike. Because if the strike is illegal, the lockout in consequence of an illegal strike is deemed to be legal. Section 23, subsection 4. This is what the scheme is. So, my lord, therefore, whenever the reference is to be made of such a nature, the legality of the lockout will be integrally connected with the legality of the strike thereof. Apparently, my lord, in the present case, this issue was simply not gone into for the simple reason the reference was not framed in that manner. Now, my lord, I will come to the observations made in the HEL case, wherein the syndicate bank principle was reiterated. Now, HEL case, my lord, will find 1996, 4 SCC, page 223. Page 223. The relevant paragraph, paragraph 4 and paragraph 5. Here, my lord, exactly the submission I made earlier, namely the legality of the lockout is integrally connected with the legality of the strike. This is what the court refers to section 24, subsection 3 in paragraph 4, HEL case. My lord has it? Yes. I read paragraph 4. Section 24 declares what are illegal strikes or illegal lockouts. It says that, quote, 24.3, a lockout declared in consequence of an illegal strike or a strike declared in consequence of an illegal lockout shall not be deemed to be illegal, meaning thereby it will be legal. If the strike is illegal and in consequence of an illegal strike there is a lockout, the lockout shall be deemed to be legal.
Shall not be deemed to be illegal. Why?
These are the draftsmen. When the draftsmen, my lord, sit and they draft a legislation, my lord, there is an old saying, somehow the intention is they should not say things directly. Things should always be spoken indirectly. Shall not be deemed to be illegal, meaning thereby, my lord, it has to be deemed to be legal.
No, it may be legal if it is shown to be so.
Precisely. Ultimately, my lord, it can't, a lockout declared in consequence of an illegal strike.
Because there was an
Shall not be deemed to be illegal.
Any lockout thereafter, that will also be legal.
Because-
That cannot be the case.
Yes, because if the strike is illegal, well, this lockout is not illegal because it is in consequence of that very strike. So two things will be required to be established. Number one, the strike is illegal.
Deemed would be a presumption.
It's a legal fiction.
It's a legal fiction.
It's
So
legal
there will be no
fiction.
legal fiction saying that it is a illegal.
So the,
legal
my lord, legal fiction means
But facts may show
the
that
legal
it is
fiction
also
would
illegal.
mean, my lord, legal fiction would mean, my lord, the moment it is established, two things are established. Number one, strike is illegal. And number two,
There is a
the lockout is in consequence of that very illegal strike.
Huh.
Nothing more is required to be established. The fiction operates. The fiction operates. So this is what it is. Now, para 5. The controversy as regards illegal strike and payment of wages for that period was considered by this court in Syndicate Bank versus K. Umesh Nayak by a constitution bench. It was held that no work, no pay is the principle applicable to public utility services. Wages during a strike period would be payable only if the strike is both legal and justified, but not payable if the strike is legal but not justified or justified but illegal. The strike may be of different forms like go slow, work to rule, refusal to work, overtime, should be irritation, it can't be. Overtime, irritation, strike, possibly creating disruptions and irritating the employer. Irritation, strike, etc. We are bound by the ratio of the said constitution bench judgment, which applies to declaration of the lockout, which is the consequence of illegal strike organized by the workmen. The lockout is both legal and justified in the present case. As a result, the workmen are not entitled to the payment of wages for the period during which the lockout continued. Of course, my lord, one may argue that both Syndicate Bank as well as HAL, these two judgments were in connection with the public utility services. Whether the law laid down in the context of a public utility service should be applied in the case of a private entity. But, my lord, to my mind, the law, my lord, the statutory prescription is there. My lord, the separate principle we can't lay down for a private utility service over and above what is there in the statute. Because the statute, my lord, section 22 speaks of public utility services. But, my lord, so far as section 24 is concerned, the section 24 uniformly applies both to the private entity as well as to the PSUs. So, my lord, we can't really make that kind of a distinction. So, my lord, so far as the Constitution Bench is concerned and the nature of the reference is concerned, my submission would be, I would rest my submission here, leaving the rest to my lord. Because either way, my lord, we have no role to play here. The reference was not at our initiative, their initiative. They could have challenged the reference nobody challenged. It was decided. And now, my lord, we are here in the certiorari jurisdiction before your lordship. Now, my lord, finally, what happened in this case? Considering the nature of reference which was made, the reference was in connection only with the lockout. As to whether the lockout was justified for a particular period, the period being 7/12/2010 to 8/3/2012. And as to whether the workmen are entitled for some relief against the lockout. Of course, my lord, they interpreted that as being the wages. What relief they may get. So whether the lockout is justified was a reference. Now here, my lord, the labor court, after looking into the evidence, came to the conclusion that lockout was unjustified as well as the strike was unjustified. So far as one aspect is concerned, my lord, I must confess, the labor court proceeded correctly. It did not examine the lockout in isolation. It examined the lockout in the context of the strike, the background of a strike, and looked into the justification of the strike also. And having come to the conclusion that the strike was also unjustified and the lockout was also unjustified, it applied the doctrine of apportionment of blame laid down in the Statesman case. This is what it did. Now, my lord, so far as the Statesman case is concerned, our argument was very clear before my lord. Our argument is that the ratio of a Statesman case was wrongly applied. The facts and circumstances in the Statesman case were entirely different. Because in the Statesman case, my lord, referring to the specific paragraphs, I pointed out that in the Statesman case, there was an expression by the union that they wanted to
work and they were not allowed.
Yes. And the employer continued with the lockout. Having found that kind of an evidence, the court said, here is a case of apportionment of blame. You are equally responsible for this situation. Over here,
Offer to work is not there.
nothing is there, my lord. Over here, there is nothing of the kind. So whether, my lord, doctrine, my lord, a legal doctrine does not operate in a vacuum. Application of the legal doctrine is based upon certain facts. On certain facts, in the Statesman case, Justice Krishna Iyer laid down the doctrine of apportionment of blame, which was also referred to in earlier cases and applied. Over here, whether we could have applied that very particular doctrine, that's the point number one. And now, my lord, this is one area wherein I address your lordship. Now, my lord, there is yet another area. Now, I will, my lord, make my submission on justification. Justification, my lord, in fact, in my arguments, I refer to, my lord, judgments of high courts, primarily, my lord, yes. That is, my lord, Bombay High Court judgment, Engineering Mazdoor Sabha versus Taki Belgarami, Metal Rolling Works, etc. Those judgments I refer to on the principle of justification. How do we examine justification as to something is justified or not justified? Therein, my lord, I also refer to the reasonableness principle, etc. But, my lord, we need not travel that far so far as justification part is concerned. For justification, my lord, the syndicate bank itself is the law on the point. The Constitution bench in the syndicate bank discuss the principle of justification. How do we examine justification? So, my lord, now I will address your lordship on this very particular facet as to whether the labor court correctly examined the evidence on record to apply the test of justification, assuming for a moment the reference is correct, as to whether the lockout was justified or not justified.
If we find that the lockout was justified, then the apportionment goes. That is what you are driving.
Naturally, if we find that the lockout was justified on evidence, two things, my lord. Number one, the labor court wrongly applied the law on justification. That's point number one. Because my argument is going to be that if we look into the principle of justification laid down in the syndicate bank case, the labor court did not apply the law correctly to understand and examine the principle of justification, to understand the nature and circumstances of lockout. This is going to be my submission. So now I will address my lord on justification, because for justification earlier, my lord, I refer to the Bombay case, Belgarami case and the rolling metal works, etc., how the court applied the principle of justification. Now, my lord, I will refer to the syndicate bank itself. What did the Supreme Court say on justification? How do we examine justification? For that, my lord, I will refer to two paragraphs in syndicate bank. These paragraphs are, my lord, paragraph 27 and paragraph 30. Court discusses how do we understand and examine the justification principle. Para 27 at page 590, I read first. It has to be remembered in this connection that a strike may be illegal if it contravenes the provisions of section 22, 23, and or 24 of the Act, or of any other law, or of the terms of employment, depending upon the facts of each case. Similarly, a strike may be justified or unjustified depending upon several factors. Now the court discusses the factors. Depending upon several factors such as the service conditions of the workmen, the nature of demands of the workmen, the cause which led to the strike, the urgency of the cause or the demands of the workmen, the reason for not resorting to the dispute resolving machinery provided by the Act, or the contract of employment, or the service rules and regulations, etc. An inquiry into these issues is essentially an inquiry into the facts, which in some cases may require taking of oral and documentary evidence. Hence, such an inquiry has to be conducted by the machinery, which is primarily invested with the jurisdiction and duty to investigate and resolve the dispute. The machinery has to come to its findings on the said issue by examining all the pros and cons of the dispute, as any other dispute between the employer and the employee. Then comes para 30. So the factors the court discussed were, my lord, service conditions of the workmen, nature of demands of the workmen, the cause which led to the strike, the urgency of the cause or the demand of the workmen, how urgent they are, the reasons for not resorting to dispute resolving machinery. They did not resort to dispute resolving machinery. They did not ask for the conciliation. In fact, my lord, it is very interesting. again, if I take my lord to the sequence of events, the fact of the matter is, my lord, the bonus, etc., is an afterthought. It was never expressly provided in any of their communication. The simmering discontent was tripartite settlement, wherein they did not want to participate. They found themselves in a very piquant situation. So it is an afterthought. Anger was because of that. There is a continuity in the strike, in fact, from the tripartite settlement itself. Continuity is there. So the pain was there. That was the pain. That was the cause. Then para 30. The question whether strike or lockout is legal or illegal does not present much difficulty for resolution, since all that is required to be examined to answer the question is whether there has been a breach of the relevant provisions. However, because legality may not, the provisions are there, the legal prescription, we look into the provision and we can find out. But the problem lies in justification part. However, whether action is justified or unjustified has to be examined by taking into consideration various factors, some of which are indicated earlier. In almost all such cases, the prominent question that arises is whether the dispute was of such a nature that its solution could not brook delay. It's a very, very important factor. And await resolution by the mechanism provided under the law or the contract or the service rules. The strike or lockout is not to be resorted to because the party concerned has a superior bargaining power or the requisite economic muscle to compel the other party to accept its demand. Such indiscriminate use of power is nothing but assertion of the rule of might is right. Its consequences are lawlessness, anarchy, and chaos in the economic activities which are most vital and fundamental to the survival of the society. Such action, when the legal machinery is available to resolve the dispute, may be hard to justify. This will be particularly so when it is resorted to by the section of the society which can well await the resolution of the dispute by the machinery provided for the same. The strike or lockout as a weapon has to be used sparingly for redressal of urgent and passing grievances when no means are available or when available means have failed to resolve it. It has to be resorted to compel the other party to the dispute to see the justice of the demand. It is not to be utilized to work hardship to the society at large so as to strengthen the bargaining power. It is for this reason that industrial legislation, such as the Act, places additional restrictions on strikes and lockouts in public utility services. As far as para 29 is concerned, my lord, the court is discussing the nature of a strike, the various forms of a strike, namely going slow is a strike, pen down is a strike, sit down is a strike, stay in is a strike. So strike doesn't mean total and complete cessation of work. Anything that disrupts the work, intentional disruption of work in any manner, or even slowing down the pace of the work is a strike. So the forms of a strike, my lord, is not in dispute. It was a strike by its very nature. Para 29, the forms have been discussed. So, my lord, if we look into these factors, I ask myself as to whether the labor court really examined these factors. What factors were taken into consideration by the labor court in forming an opinion that the lockout is unjustified, that the strike is unjustified? The strike is unjustified, I understand. The strike is indeed unjustified. Whether the lockout is unjustified, what factors were taken into consideration? What was our demand? My lord, here is a case where lockout was indeed the consequence of the strike. Of course, since the word justified has been used, I can only submit here the lockout was in consequence of an unjustified strike. Because legality is not the part of the reference at all.
The workmen have not challenged that finding of the
Yes, they have
court.
thought that I submitted earlier.
And strike was unjustified.
Yes, but there is no challenge to
What
that.
it means the
Yes.
strike is unjustified.
That is it.
Now
Why
we
lockout
see
is
whether-
justified?
Whether the lockout was justified or unjustified. If it was justified, entire blame on the workmen.
Yes.
If it was not justified, even
Apportionment of blame comes in. but whether it is rightly applied.
Rightly applied.
My submission is lockout is unjustified. Sorry, lockout is indeed justified.
Justified.
Because number one, it was consequence of an unjustified strike. And number two, because the circumstances, my lord, indeed were such. Here, my lord, Balgarami comes in those Bombay High Court judgments, the present and clear danger and threat. Because in the Bombay case, my lord, those factors were present. The nature of danger to the employer, the circumstances under which the lockout was resorted to. Of course, my lord, at that very point of time, my esteemed colleague, my lord, took offense. But, my lord, in passing, my lord, I mentioned that it is likely to be argued the long duration of the lockout. And indeed, my lord, this is what exactly my esteemed colleague pointed out. So I said I anticipated that. Here, my lord, as to whether the lockout was long, no evidence was adduced on that it was wholly unjustified, that it is the long duration of lockout which has made it unjustified. I asked myself whether at any point of time, the workman submitted a representation to the employer expressing a desire to work during this period that recall the lockout. We want to negotiate. We want to sit for parleys. There is nothing on record. And, my lord, in any case, this was never argued by them while adducing evidence. It was never their case at any point of time. This is the case they are trying to build up now at this stage. So, my lord, the continuation of lockout for a certain degree of period cannot be an issue for my lord to look into this aspect. At this stage, certainly in a certiorari jurisdiction. This was never before the Labour Court. So, my lord, I asked myself what factors have been considered by the Labour Court. Again, my lord, let us look into the judgment. My lord, it is paragraph 21 and 22. Para 21 of the judgment, page 170 of the paper book. Para 21, my lord, practically the law is being discussed. What is lockout, weapon, etc., how it can be used as a weapon. Nothing on evidence as such. Para 22, my lord, I read the observations of the court. In our case, it is seen, court is referring to the present case. Para 22, page 170 of the paper book. In our case, it is seen that taking the plea of management's insincerity in solving out the problems of the workers, started agitational program and it continued for a long time. So management failed to solve their problem and workers started agitation. My lord, let us pause here for a moment. I ask myself here, tripartite settlement we know, it is for solving other problems. They were not interested in tripartite settlement. They didn't take part. A strike continues. Whose insincerity? What insincerity? So far as the first part is concerned, there is a tripartite settlement. Where is the evidence that A, B, C demands were made and management did not solve A, B, C demands? That management did not want to sit for a conciliation. That adjudicatory mechanism was resorted to. That there was inordinate delay on the part of the management. Where is all that? There is no discussion on that. The management's plea is that the agitational programs turned violent and law and order situation arose. Before taking the agitational program or during the agitation, the worker did not approach the Assistant Labour Commissioner for his intervention into the matter. Correctly. This is what the syndicate bank ratio is. The workers could have got the matter referred to the court by approaching either before the Assistant Labour Commissioner or by filing a petition before the government. The strike of the workers may be for a just cause, but law doesn't permit the workers to go for a strike and any other agitational program when there are other ways. In the case of management of Chandramalai State, Ernakulam versus its workmen and another, 1993 is such. The Honorable Apex Court set aside the order passed by the London Tribunal awarding 50% of the back wages during the strike period to the workers on the ground that the workers did not avail the right of getting the matter referred to the government. When the conciliation failed in the said judgment, it was held that, while on the other hand, it has to be remembered, the entire quotation is from the management of Chandramalai. Then, para 23, summing up the materials on record, it reveals that declaring of lockout on Assam Carbon Products Limited, Birkuchi, Guwahati 26 was unjustified. Thus, the issue number 1 is decided in negative. That is why, my lord, I submit it is perverse, being based on no evidence. The labor court doesn't discuss the factors and circumstances. What led labor court to come to the conclusion that the lockout is unjustified, my lord, is hardly discussed here on the basis of the evidence. Now, my lord, lordship, we get some indication in page 168 of the paper book. Paragraph 15, the last subpara at page 168. Here some indication is there. We get some insight into the mind of the labor court. I read at page 168, the last subpara of para 15 of the judgment. Though in our case, it was alleged that the workers indulged agitational programs like strike, mass casual leave, karma biroti, etc. But it has not come before the court what steps the management had taken against their end workers. My lord, by submission, it is irrelevant what steps we had taken. The management is silent about the demand raised by the workers. Now, my lord, I ask myself, what demands were raised? What is the evidence on demand? There is no evidence on demand. In passing, my lord, we get references of bonus, etc. There is no categorical stand on that. Thus, it has not been proved that the demands of the workers were unjustified. Now, my lord, it is wonderful. The labor court itself does not talk about the demand. It does not refer to the evidence on demand. It says, therefore, the demands were not unjustified. This is what the perversity is. And that is why, my lord, we are seeking the writ of certiorari for setting aside the award of the labor court.
Here he says that it has not been proved that the demands were unjustified.
Demands are.
Goes
In
on
fact,
to hold that the strike was unjustified.
One has to take extra pain to discover, looking everywhere, what exactly were the demands. The demands are the most important thing. In black and white, you have to begin with the demand categorically. This is the evidence, this is the demand, this is how demands were raised. This is what the management did. Fact is, my lord, demands were never there. The demand that tripartite settlement, that is the pain. Therein lies the anger. The whole idea was the union wanted to flex its muscle. Another union came into being. That union entered into negotiation. It became a party to the tripartite settlement. This union found itself sidelined, so they wanted to show their power. This is what it is all about, the whole cases. We may keep on, my lord, entering into the legal jugglery. It will not take us anywhere.
Do we have the charter of demand anywhere exhibited in this?
My lord, my learned friend will educate us as and when his turn comes. I would like to.
Was it here?
My lord,
was it referred to in the
honestly, my lord, I couldn't find it. Honestly.
exhibit number? We can.
Certainly, my learned friend will enlighten me where it is. His turn will come. He will certainly. I would like to be educated on various facets of this case, which otherwise, my lord, I find very interesting. So, my lord, the perversity and how perversity comes. So, my lord, I submit that there is no material to hold that the lockout was unjustified. The findings of the labor court are absolutely perverse.
Yes.
Practically, my lord, this is what our case is. subject to whatever comes from my esteemed colleague, my lord, I will make my submissions, my lord, or if need be, my lord, whatever I have given to my lord, I may polish it later on, because this is at this stage, subject to whatever comes from the other side, my lord, I will outline the entire framework of my argument, my lord, in a synopsis. I'll make a synopsis of my arguments, short synopsis, point wise.
Yes.
Oh, yes, I can, because my learned friend is drawing my attention, because I simply did not read the whole paragraph. I forgot that last paragraph, last subpara of para 15 itself, at page 168 of the paper book. I was reading that, I wrote the first 3 lines and I went on without making submission, so I forgot to read the other lines. I rather finished the whole paragraph. So in our case, it was alleged that the workers indulged agitational programs like strikes, mass casual leave, karma biroti, etc. But it has not come before this court what the steps management had taken against the errant workers. The management is silent about the demands raised by the workers. Thus, it has not been proved that the demands of the workers was just unjustified. The management refers one MOS, Memorandum of Settlement, and it is stated that the workers had committed 23/7/2008 settlement they are talking about, on which there was a tripartite settlement, etc. And which my esteemed colleague very fairly said, yes, it is binding on everybody. Memorandum refers, management refers one MOS, and it is stated that the workers had committed to fulfill the norms set by the said MOS, but the said MOS has not been produced before this court by the management. So they are doubting the very existence of the MOS. And my esteemed colleague has been very fair on that count. So I need not even. This is absolutely doesn't stand to scrutiny. This very MOS, my lord, has been held to be binding by the Honorable Court in another judgment of it. The same MOS, 4068. I think copy of that judgment possibly we gave it to your lordship. It is there. Yes. 4064. Or 4064. Justice made his judgment. In any case, my lord, my learned friend is not disputing that part. He is not on that. So, my lord, the perversity is writ large in this case. So, this is the sum and substance, my lord. It all depends upon my esteemed colleague, my lord, to what extent, and thereafter, my lord, I'll give my replies.
Yes, sir.
Lordship may kindly fix a date, day after tomorrow, for my reply,
Tomorrow.
or any date.
After tomorrow, I think we already fixed some matters.
Really,
Some matter fixed হয়েছে নাকি?
we had a discussion yesterday, my lord. Any convenient date.
এইটো আগৰ যে মেটাৰটো সেইটো কেতিয়া ফিক্স কৰিলি আইটেম 16 17 টো
Let it be after the marriage of your son.
5 টোৰ আছে ন তেতিয়াহলে পেছত ল'ব পাৰি 27th is convenient sir
27 is not convenient.
27th is Thursday, November, 27th November. Yes, I'm here.
Let it be after. Then Thursday or any regular.
27th
That will go after 15
Keep it on
December.
27 since we are hearing the matter and we only have 2 weeks in between
27th.
27 then if it continues
27th
we have
November.
one more week, huh? 27th if it is convenient for both of you.
It's convenient for me, my lord. Certainly, I'm here.
27 November, there is a fixed case, my lord, on 27 November.
But that is
All
unlikely
India
to be
Limited-
done.
All India Limited versus.
He says it is unlikely to be done.
That is, of course,
This is, Mr. Goswami is not coming.
Off the record he is assuring that this matter will be done and not that one. Off the
That's-
record.
Of the record, he's saying that.
But I am pressing, let it be, let us have for 27.
Because, my lord, in that case, it
Then
will
the-
go after 15 December. That's my difficulty. Election petitions and other cases are lined up.
After 18 December?
After 18 December, all right, but 18
After
December
18
holidays
December, we'll
begin.
have only one day, 19 December.
Then it will be in the month of January.
My lord,
Then it has to be released.
Oh, then day after tomorrow.
let it be day after.
We'll try day after tomorrow. If happens, it
Tomorrow,
happens.
day after tomorrow, one matter has been
Huh?
fixed. Or tomorrow it can be fixed.
Tomorrow we,
No,
the
To be very frank.
list is already there.
My son's marriage is in Turkey. That is the problem. Otherwise, I would never.
But the day after tomorrow would also be difficult. Tomorrow is what we were saying. If you can sum up your submissions.
Day after, let it be day after.
Day after tomorrow, my fixed case was, no?
He's saying it's not going to be done.
That is his submission. The court may not accept it. It's a long pending case.
2nd of December? No.
Oh, yes, no problem.
So we, if we have to keep it part, then we cannot fix it in January.
No, 2nd of December or tomorrow or except day after tomorrow. 2nd of December, all right.
Minister,
No
but,
problem.
I won't be present. It could be on 8th December, it can be 8th. 8th I'm present.
All right.
2nd I'm not, my lord. Election petitions are there in Itanagar.
এইটোতো সেইখন অহা নাই ন তখনতো অহা নাই নাথাকিলে আকৌ ভিচি মাৰিব লাগিব
8th December I'm here, my lord.
The roster is there till the
That is
5th. So 8th I do not know where I am. If I am out, then it has.
My lord, let it be day after. Let us see how busy my learned friend is.
No. Day after, no, because
You
a
want
long
tomorrow?
pending case I have.
You want it tomorrow
Let it be,
Tomorrow or 2nd.
let it be tomorrow.
or 2nd?
Second.
Tomorrow.
Let it be 2nd.
2nd is.
Then I'm not present at least. I know about myself. I'm not present.
We can have it on 2nd. He may have his submission. Yes, you need to reply.
That is it. But I will not be present on 2nd. That is for sure. Tomorrow I'm here. Tomorrow I'm here. Day after that I'm here.
They are presented to Silver.
Huh?
They are presented to Silver.
8th December. He is not sure. Lordship is not sure.
8th. 27th the next date.
8th.
27th the patient date to guess, sir.
Fixed, no. At least one. There are 9 matters fixed for tomorrow.
Tomorrow. Then not in. This matter will take some time, so far I am concerned.
But
Not very much time, like half an hour or
52 video not a fixed. We'll try tomorrow.
Fine.
Let us try
Fine,
tomorrow.
fine.
If it is half an hour, we'll squeeze it out.
Fine. Better.
Find that time.
tomorrow better.
Tomorrow at 2, my lord? At 2?
Yeah, 2.
Let it be at 2 because first part lordship will very well.
Tomorrow case name.
Because these days not many lawyers are keen on doing cases. So it may so happen that.
That will be better. Tomorrow will be better.
Tomorrow is not Tuesday. Today is Tuesday. So we had the time.
Today itself lordship has seen practically nobody was ready.
Tomorrow is again Wednesday, so.
Tomorrow, is there any problem on your part?
Nothing. There's a number of matters which come up in.
Tomorrow.
So lordship,
tomorrow.
let
We'll
us
have
fix
it
it at
tomorrow.
2, my lord. Let us fix this case at 2.
Huh.
Tomorrow at 2 p.m.
Tomorrow at 2.
That will be better.
Better.
The
Can I-
business matter again tomorrow will be hol.
So tomorrow at 2 p.m.
Tomorrow, we are not saying in the order at 2 p.m.
But it is understood at 2.
We'll try to accommodate at 2.
That will be better.
Unless some other part or matter is going on,
Oh,
we'll
yeah.
try to accommodate at 2.
In the meantime, I may be permitted to check up the records.
Please.
Some exhibits such.
Attendance to এলাকানে লিস্ট করাই দিলে আর ওটা থাকিল নেকি হৈ গ'ল গোটেইটা হৈ গ'ল আহিছে এখন থব এখন থব সেইটো এখন ন